that we didn't resolve yesterday. The first is the introduction of a video. Have you guys agreed to the redactions?
Yes, so I have agreed that if the court overrules my objections on what we talked about yesterday, then the redaction.
That discussion was not on the record.
I understand.
So go ahead and make your objection to the redacted portion.
Okay, so under the redacted portion, it's our position that that under Rule 403, it serves to confuse the issue. It's specifically the issue of how the security worked at Rodriguez Park on April 21st, 2019, the Easter Sunday. We've heard testimony from the park director, Mr. McGlamory, that has said, I guess clearly and unequivocally, that the pavilion security is completely separate from the park security. And based upon the tenor of the interview, it seems like that could put the issue back into play and should not be into play because I think everybody agrees based upon the state's witness that was the case on Easter Sunday. So playing that video in the way that the conversation is, we would argue that it confuses that issue and therefore, and otherwise, if their attempt to use it is, I guess, for a specific instance of conduct that she was paid for stuff out of her own, I guess paid for the officers out of her own money.
That's what I think they're calling a statement against interest.
Well, their witness testified to it on the stand, so they brought that out from their own witness, and then they're trying to add on to that. So it's kind of like they're opening the door to this statement by having their own witness testify to it on direct examination. She said, which is Officer Osiris David, who said, "Yeah, she paid for it out of her own money," and we didn't elicit that statement. And so that's another, that's kind of another issue. So I think in total that there's no reason, there's no relevance to play the video. Under 403 is confusing. They're trying to offer it as a specific instance of bad act or conduct that they did not give us any notice of. They did not say anything about the fact that they were going to do that, and it's not on any of their 403 notices.
Okay, State, what are you offering it for?
So I guess first to address
first of all, hang on, I'm sorry, Oscar, didn't mean to interrupt you, but there's no issue with authenticity based on 38111?
No, Your Honor, we agree with that.
Okay.
Okay, so first to go to the issue of confusion. As far as it goes to the way the security operated and all that, it's been cleared up through the witnesses. It only becomes confusing when you introduce the defendant's statement about that, which goes to show her consciousness of guilt regarding that, the way that security was set up. Also, we would argue that based on an admitted piece of evidence, Exhibit 10 in particular, that statement that she gives the media is inconsistent with what was written on that statement. In that she states in that statement that...
So your argument to the jury is we have proof beyond a reasonable doubt she gave an inconsistent statement because of this video?
Yes.
Well, in that instance, the video would not be introduced as an exhibit if they were trying to offer for impeachment. They can't offer the actual item of evidence. Just as my, I guess, audio recording of Susan Tristan saying that Michelle told her to tell the truth is not an actual exhibit. It can only be played.
Well, so it's the statement by the party opponent about the facts regarding what happened Easter Sunday, and with regard to Mr. Goss's recent argument, we also say Rule 806 comes into play because her credibility has been put at issue. That is, Exhibit 10 says, well, this is what happened. It's a business record because it recorded the event immediately after, soon after, whatever. And we know that that is inconsistent with the statement that she gave the media.
Well, first of all, Exhibit 10 is a statement of Susan Tristan. She cannot be impeached on a statement of Susan Tristan.
So what was testified to was that Susan Tristan didn't have knowledge of what happened on the field, so she received what the defendant's statement was regarding what happened and wrote it down. That's what was testified.
Right, so
that's why the state argued hearsay within hearsay, because it came from the defendant being introduced by defense. But when that was admitted, the court admitted under the rationale that it was...
Her testimony is that the constable made me write it. Her writing doesn't indicate that, right?
That the constable dictated for me what to write. Yes.
And nowhere on her statement did she say per the dictation of the constable.
Through her testimony.
Right. I'm not going to relitigate that. That's it.
Yes. So it's a statement by the defendant that that Susan Tristan writes down. That is, she doesn't have any knowledge of what happened out there, but for the defendant telling her that. So it is, in effect, a statement by the defendant.
Well, that same statement was introduced by the prosecution as well. So they've also introduced that statement, and introduced that document.
And now we're showing that it's inconsistent with what was said to the media. Which again goes to relevant facts regarding this case with Rodriguez Park. If this case is about Rodriguez Park, and she is giving a statement about Rodriguez Park.
The redacted portion, that the time stamps that you all gave me yesterday, that's admissible.
Okay.
I'm admitting it, overruling your objections.
Your Honor, in that instance, we do have a portion that we'd like to play for the court that we would ask to offer under optional completeness, that it ought to, in fairness, be considered contemporaneously, meaning when they play that portion, they should play this.
What is that?
I can play.
I gave it back to Oscar Allen.
I can play it for the court right now. Right now, I just have an audio on my phone. We're trying to get it, the video all done, but I can play it for the...
There's an issue with me through the county. If, give me some kind of legal writing. Give me something in writing. Tell me, hey, Constable, we have a problem. This is what's going on. Or at least have the courtesy to reach out to me, discuss, Constable, this is what's going on. What are the concerns here? Is it something that, we need to look into? Not. Let's sit together as elected officials and discuss this. I've never been given the opportunity by any elected official here within Bexar County to have the decency to sit down and have a decent conversation.
That is
Here,
just,
as you know, the
that is
district
going to open
attorney,
the door to
Gonzalez,
all sorts
has
of
stated in the
issues
past
that
that he
are not related
represents
to
me.
tampering.
Your Honor, she continues.
I saw the whole thing, so I know the portion you're asking me. I saw that whatever Oscar's on Oscar's USB, that's what I saw and heard.
Then at least the portion where she says specifically to Rodriguez Park, there was no criminal activity at Rodriguez Park. So if I could go to the end here.
They would argue a self-serving
Forward,
statement.
and I'm directed this to the DA's office. If that's something they're going to proceed forward with, then please bring all the facts, because I have all my facts.
I heard all of that too.
So that
And it gave me pause to hear her say that she thought Joe Gonzalez's office represented her. I'm assuming that was already covered and not an issue at all, right?
Yes.
Well, this interview was done before they set the subpoena.
She says in that interview, Joe Gonzalez represents me, which
And-
gave me great pause. But I'm assuming because we're on the last witness of this trial that it's not an issue.
Yes, Your Honor. Yes, Your Honor.
So I am not going to let that in.
I guess what I'm saying is that I think what she was referring to in the civil capacity, because he represents all county employees.
Correct. And
Simply.
when I say it's not an issue, I mean they vetted it and the DA's office did not have a single conflict in proceeding with the prosecution because there may not have been any civil stuff going on.
Yes, Your Honor. It was the reason, I think Mr. Sakana was testified, that was the reason she hired less, is because the DA's office was the people that were prosecuting, so she couldn't have them help her comply with the subpoena, so she had
Okay.
to...
At this time, that portion is not going to come in. Your offer is overruled. I cannot let that in. I'm going to let the part in that you all agreed to. And I'm saying at this time, if the testimony develops differently and I need to consider it again, I will. But at this time, it's denied.
Yes, Your Honor. So just for the purpose of the record, since I don't have an actual copy, I will make a copy of that. We will mark it as a defense exhibit. I don't have one right now, but we will mark it as a defense exhibit for the appellate court. And for the
Yes,
appellate
let's do
record.
that. Let's do that. That would be defense exhibit, I believe, 14. David.
Suggestion would be entering the whole one as a court exhibit.
The whole one, I guess, is a court exhibit, but, I will have a disc that has our specific part so that the appellate court will know that defense 14 is what we tried to offer as,
Yes.
ought to, in fairness, be considered contemporaneously with the offering of the state. And we maintain all of our other objections to that, and to the item. So what I've agreed to is that the version that they have, the redacted version, does not talk about any other extraneous other than Rodriguez Park.
And one thing that I need to do, Judge, is I already made a redacted portion, the 5 minutes or so. However, within that redacted portion, there's the reporter making a statement. Yes, Mr. Dawson and I talked, that needs to be redacted also and muted. The redaction is ready, so I'm just going to go upstairs and pick that up real quick.
And Your Honor, do you want the thumb drive put into evidence that you reviewed?
That, it's not marked yet, but it has Oscar's other work that I did not open.
Oh, okay.
I think maybe let courts do it next in order, forward maybe, for that one.
So we're not playing that video right now, right? There's, that's still
No,
away.
I've got to build back up to it.
Okay, let's go over the exhibit, what's that big exhibit, Don? 46, 47?
The 211 page
Yes,
one?
it's number one.
It's 46 dash.
Let's take up that
46.
objection now.
I'm sorry, I'm messing this up again.
Taylor, what room are we in? Room?
46-2.
Let's take up the objection of 46-2. Okay, yesterday we left off, and I really don't want to rehash the entire argument. That argument was on the record,
Okay, Judge.
right? We did
believe
argue
it
this
was.
point on the record.
Yes.
Yes, the
And just for review.
scan, yes, oh, okay.
I review, we maintained that objection under Code of Criminal Procedure at the time, 20.02 of grand jury secrecy. We've maintained the position all along that there's not an exception for the state. The only exception is if there's a particularized needs for the citizen accused, and it still has to go through a process. So we're not going to waive that. The issue I think that you're referring to, Judge, from yesterday was the authenticity aspect of it. The fact that Dawn received it from
On the chain of custody.
chain of custody, which, yes, goes to that as well. And Dawn actually received it, as she said yesterday, scanned it in, and then handed it over, as we found out during testimony, to Ranger Freeman, which was something new that we didn't know previous days. So that was the issue from yesterday.
Ma'am?
Yes, ma'am. I'm trying to recall if Les said he handed it to Freeman.
There were two times, and that's why they brought Scott McNaughton in. There was a meeting first, then Dawn represented to the court that she looked at it. She said, Les, we don't have a business record affidavit. Go back and get a business record affidavit, give it to Freeman. But then she also notified us at several times that she scanned it in. Now, the new thing that came up yesterday was during testimony, Ranger Freeman said Dawn handed it to him. So that was a whole new factor here. So she received it from Les, scanned it in. Our opinion, Judge, our position is the chain of custody ended there. She's at the end. She's the state. She's the chain of custody. She handed it to Ranger Freeman, and of course handed it back to Les, but it doesn't matter. The chain of custody ended with her. And so she's part of the chain of custody, and as we know, she can't testify.
It's not that I can't.
Well, yes, we maintain the
No,
position we
actually,
can.
that's not the rule. I can do so to clarify anything, and if you so choose, off the record for your clarification, because you're the one who has to decide admissibility. As you had mentioned yesterday, it only goes to the weight, not the admissibility, and that is your decision to make, and therefore you can hear from me off the record out of the presence of the jury. However, I would like to object to having to prove the chain of custody of documents obtained by a grand jury subpoena, because that is also not the rule. But if you so require, I have looked into the documents to better define the chain. And so one of the things I realized this morning is that the indictment itself says on or about June 26, 2019, the record was concealed. The reason I use that day is that's the day I received the documents from Les when the missing documents were not included. I should have realized that yesterday. It was an oversight on my part. However, I realized it this morning. Secondly, we have State's Exhibit 40 that I had previously marked, had not gotten it to it yet, because this begins an email from Ranger Freeman to the defendant, and it's dated July the 1st. And he goes on to ask her, upon receipt and review of your response to the Bexar County Grand Jury Subpoena dated June 11, 2019, for records related to Rodriguez Park, I have noted the following. And he said, number one, the lack of names for deputy constables who are assigned to work Rodriguez Park events. And two, the lack of corresponding security agreements as compared to receipts and park reservations scheduled through Bexar County Parks. Was this an oversight, or do these records not exist? When we first spoke after my delivery of the subpoena, you gave me the impression you had a list and/or schedule of the deputies who were assigned to work. I recall you saying you and your chief deputy worked most of the events. Thanks in advance for your response. And that is on June 1st of 2019.
Not June 1st.
I'm sorry, July 1st. On July 2nd, the defendant responds. She says, at one point, most of the deputies, excluding a small amount within my office, have worked a part-time, and in parentheses, she writes, side job not pertaining to Bexar County, at Rodriguez Park, including myself and Chief Castillo. The clerk within my office has provided the documents she had. In turn, I handed them to my attorney who is representing me. In parentheses, she writes, not a county attorney, to hand to the Bexar County District Attorney's Office last week sometime. All information has been provided already to the Bexar County District Attorney's Office. Also, keep in mind, my clerk made an affidavit which was included with those documents. As we know, Les testified he handed me the 211 documents. With it was the affidavit from the clerk. So I believe this email clarifies that the defendant gave those documents to her attorney. Her attorney provided them to me, confirming that it was the week prior to July 2nd, which corresponds to the indictment stating June 26 of 2019. That would be the week prior, thereby confirming delivery to me of the 211 pages and the 3-page affidavit.
Judges, that's not referencing when she got it. We don't even know when she got these 211 pages. She couldn't testify. Scott, she didn't represent to the court. Scott McNaughton did not say anything. So that's a discussion previous. So that's fine between her and her lawyer. But once Les came to her, she's the end of the chain of custody. That's our position. So that's a reference to a previous conversation. That's fine. We can argue that and we can make our advocacy points there. But once Les went from that conversation, which is referencing back, to Dawn, and she received it, scanned it in, and then transferred it over to Ranger Freeman, that's where the chain ends. She's part of the chain of custody. I know she doesn't like it. She's in charge of this investigation. She chose the dates. She chose what happened in the procedure. She could have said, Les, don't give me anything, and she didn't. She received it and scanned it, and she knows it.
There are no requirements to prove chain of custody on documents. Additionally, we know that Ranger
But you
Freeman,
also don't have a business records affidavit with the 211.
which was part of the problem. And so then I have emails between Les and I talking about when we met that second time. And we met on August the 2nd, of 2019. His emails, I go into great detail about why we were going to have this meeting, that he was coming in because there was a failure to give us business records affidavits, and I'm providing him blanks. I'm handing him a copy back. I lay out the whole procedure.
But she already has them by this
So
time.
let me just be real clear. There is a second time when Les hands the 3-page affidavit and the 211 and hands it to the ranger.
Yes, that is our understanding, Judge.
So all I'm tasked with is whether or not that is purports to be what Les gave him.
Okay.
And so on that basis, while it's very shaky and it's not the preferred way to handle evidence, that's going to come in.
Okay,
That
and-
exhibit is coming in.
Okay, Judge.
And you guys are just going to have to argue your
Sure.
case.
Sure, but
But none of what we have discussed regarding Dawn and Les, I think Les only said that he saw Dawn and he gave it to her. He saw her by the elevator and gave it to her. In fact, there was a very brief discussion about that. Do not go into anything that has not been brought up by the evidence regarding this issue, because I am making a determination specifically based on that second August date where Les finally returns with a 3-page business record affidavit and 211 pages and hands it to the ranger. Under that basis, I'm admitting.
yes, Judge. And just for clarity for the record, I want to make sure it doesn't come across like we're waiving. What Jason was arguing yesterday, that now we appear to have 2 sets of documents. We were not provided 2 sets of documents in discovery, so we could compare them, so we could be effective for Michelle and see, okay, where the documents that Dawn received and scanned in, and the documents that the ranger received and then eventually scanned in, we have not received them, we didn't know of them, and we have not compared them.
I understand, and that objection is overruled, and so is the violation to the secrecy of the grand jury. It's overruled. That's, something that definitely you guys can argue on appeal if it has to get to that. But it's shaky, but I'm letting it in. I'm making the call. It's coming in.
Your Honor, and I apologize, I know that the last issue was finished, but I'd like to go back to it briefly. I do have an objection to the authenticity under 38111, because if you read the plain language of 38111, it has to be a purported broadcast, and there's no evidence that this was actually broadcast. You can't tell by the video itself that it was a broadcast. And a broadcast means not, I recorded a video in an office somewhere. A broadcast
Was
means
this broadcast?
it went out over the news
She
media.
saw it, that's how we saw it. We could elicit questions. Yes,
So was it
broadcast.
broadcast on the
Yes.
news?
Yes.
That portion. In its entirety, that's the other issue, is like, did they broadcast that?
What
whole
was
thing?
broadcast?
The entire interview.
Do you know what platform it was?
WOAI?
It's WOAI Kansas. It was with Matthew Seedorf.
And we could elicit questions from the ranger about how he came into viewing this and where he viewed it. He viewed it off of a TV program.
That's fine.
I guess the question is, though, is that from the video itself, there's no evidence, no indication that it was broadcast. That portion. And so I still don't, I would like to, was it broadcast on the nightly news? I'll just tell you, we had a whole trial and maybe 4 seconds or 30 seconds of clips on the news. So I am dubious to believe that this entire thing in its entirety was like took up a whole news hour one night. And so if that's not the case, if that's not what happened, then what did happen? Where
The
was
rule
it?
requires the entire part to be broadcast?
The rule does not require that. The rule requires that we know that it's authentic because she gave it as a part of a news broadcast. So now we have that portion that she gave, or that we gave that. Give me tongue tied, Judge.
The problem with that, if they want the entire thing in, it's all about the arrest of Leo Moreno, and that would violate their own
Here's what I'm
rights.
saying, and Judge, please understand, every time we talk about something, the fact that they're just trying to get into everything, here's what I'm saying. I'm not saying that the rule requires that the entire thing must be broadcast. But if this, for instance, was a video where it's like, and next, we're talking to Constable Vela, and here's an interview, and then you can actually tell by the way that the video is that it was a broadcast. But in this one, it looks like raw footage, is my point. How much of that raw footage was actually broadcast? Because what they did was they subpoenaed all the raw footage for it. And so if this was something that happened that wasn't part of a broadcast, then the rule specifically states broadcast. And broadcast specifically means that it went out to the public, not that it was just a video shot and not raw footage. That would not be required. So the portion that they want to play, I'm not saying the whole thing, I'm saying the portion they want to play, they have to show that it was actually broadcast out to
I
someone.
disagree. I'm reading the rule. I disagree. The redacted portion is still coming in. Anything else?
Not from the state.
May I go upstairs to go get the...
Do you want to do that inquiry outside the presence of the jury? I don't. Whatever you were going to more dire him on.
May I order?
But you need the recording, and he has to go get it. So go get it.
redacted one.
Tell the jury.
still have yours.
for the law enforcement security there on Easter Day. That's something that a lot of people don't know. We were contacted by Kenneth McLambry, the Parks and Recs manager that's over Henry, by email as well as by phone, saying, Constable, we need 4 officers or deputies that can provide security for the day of Easter. I was like, okay, no problem, we'll accommodate. Again, I was going to have an Easter event for my office, but, you know, depending on the Bexar County commissioners, when I first took office, told me, hey, you're in charge of Rodriguez Park, you need to take care of the law enforcement security. So that kind of sometimes I have to put some things aside on my office to make sure we're able to handle the Rodriguez Park and take care of what's needed. And that's what I did. I canceled an event, went out there. We did the amount of hours that they requested us to be. Now, the problem that we had out there is that me and my chief were scheduled to work from 7:15 to approximately 3 o'clock. And the individual that showed up at Pavilion number 1 was beginning to drink alcohol and so forth. Now, this individual, if you go down to the Bexar County Parks and Recs, on their forms, it'll state that they must contact the Bexar County Constable's office. So they've already been informed, and they also sign a form with them. And they're also informed that if they don't follow their policies, that the Bexar County Constables can go over there and shut down their party. Now, that's not something that we did that day. We elected to only have alcohol, and this is what occurs as far as policies and procedures and the contact that you're supposed to make to set law enforcement. Nowhere in time did we ever squeeze any money out of them. Everyone that's ever rented the pavilion at Rodriguez Park has paid for law enforcement security if they had alcohol. And so that's one of the requirements. That's correct. That's exactly what it said. It said I was trying to squeeze money. Now, keep in mind, again, I've referred over to the Parks and Recs contract, I'll call it a contract with them, where they give them all their rules and policies of what they expect and how they're supposed to contact, again, the constable's office. If they have alcohol, then yes, they are supposed to have law enforcement security. They also advise that if they don't follow this, that when we arrive at the park, that we're able to go ahead and shut down their party. Keep in mind, I did not shut their party down. I elected to tell them, this is what occurs, these are your options. And so he, at first, you know, I believe I'm going to assume it's a wife because she referred to him as a wife, was upset saying, well, I have, my family works for Bexar County Sheriff and they'll just come over here and take care of everything for us. Well, unfortunately, I had to apologize and I'm sorry, ma'am, but this is something that the Parks and Recs has with my office, that we're the ones that take care of all the security here. And as the night goes by, we actually checked out, me and my chief, at 1 o'clock from the job that we were doing for the parks. And we began providing security for him from 1 to 7, paid security, where I got $150 and Chief got $150. So it's $300 total together, but it's only $150 for each officer. Now, he also apologized, Mr. Reyes, saying, I'm sorry for being a little hard on you, but I understand, you guys are just doing your job, so we're just going to pay for the law enforcement security. You're right, we call your office. And that's how that went. Now, getting back to the officers not getting paid, it was me, myself, chief, and 2 deputies that were supposed to be there at a later time. When we went to Bexar County to pick up the checks, which was approved by Bexar County commissioners for funding, the payroll didn't have our checks available. It's supposed to be a separate check from the payroll because it's a part-time job. And so that's something that, we do our own taxes and whatnot. Now, when we were over there, they weren't ready, so we opted not to go ahead and proceed forward. There was too much inconsistencies in the stories between who's getting what money and this and that. That I said, okay, not a problem, won't take anything today. What I decided to do was go ahead and pay both officers. I paid them each over $200. And then my chief, I was going to pay him, but he decided to donate his time because he didn't feel it was right. I was paying him. And then I donated my time. My question to the commissioners was, where was all that money at? And again, the constituents they're not even aware that the Bexar County Parks nor the commissioners ever paid for that law enforcement security there. I paid for the law enforcement security for the constituents on Easter Sunday, April 21st, 2019. No one else did.
Okay.
Do you still want to inquire?
Yes, Judge.
Go ahead. So we're on the record. I was like, for the jury. What exhibit number is this, Oscar?
Doesn't have one yet. can you, I think it'll be 74 is your next one?
Yes, it is.
And Your Honor, we're having Mr. LaHood for an hour because, just to keep consistency, because he's on cross.
Yes, we're doing the voir dire about this exhibit so that we can let the jury in and not have to excuse them again.
May I proceed, Judge?
Yes, sir.
Ranger Freeman, is this the first time you've seen that video?
No, sir.
When is the first time you've seen it?
It had to be around the July 15th time period. I don't know the exact date that I saw it.
This extended, you didn't see this on the news though, right?
I can't recall seeing it on the news.
Well, you watch a lot of news, correct?
I try not to, Nico.
Well, I don't blame you. No, you call me Nico. Yeah, I don't blame you.
Well, call me Brad if you
Yes,
would.
yes, sir. I don't blame you. But what I'm saying, you know enough about the news that they live in sound bites, correct? The news lives in sound bites.
Yes.
Okay. And that this is more than a sound bite, correct?
This is an interview.
This is an interview. So I want to make sure it's clear. You can't tell this court that you saw this as part of a broadcasted news story on a news station, correct?
I can't remember exactly where I saw it or how I remember being notified that a statement had been made. I considered it as an investigator a statement, a witness statement. So I grabbed it.
Well, and you said something specific. So you were notified that a statement was being made.
Yep.
Made. So then you got the raw footage, correct?
I subpoenaed it, yes, sir.
Okay. And then that's normal. That's what you do in investigations. And once you got the raw footage, then you watched the whole. Well, we'll just call it the raw footage of the whole interaction, correct?
Yes.
Thank you, Ranger.
And Your Honor, I'll continue because I was at the argument motion. So as we talked about, I mean, the rule here in the definition of broadcast under Merriam-Webster is to send out or transmit something such as a program by means of radio or television or by streaming over the internet. And there is nothing on the face of this video that shows that it was broadcast. Ranger Freeman went and
When
watched.
you're adding that, the statute doesn't say that on the face of the video, there has to be proof that it was a broadcast.
Well, it says it purports to be a broadcast. That's what it means, is that it purports
So why
to be a
doesn't anyone
broadcast.
ask him how he came to get the video and view it?
Well, what he said was is that he didn't watch it on a broadcast. It wasn't broadcast. This is raw footage of an interview that there's no evidence was actually broadcast out to the public.
Can Don ask those questions to clarify that point?
I mean, that was the purpose of voir dire, so
Well, Ranger Freeman, you agree that you did not see it on a broadcast. You got the raw footage, and then that's where you saw this video.
No, sir. I just don't remember exactly how I came across knowing that this existed. I mean, as I look at my report, I can tell you I found out that this existed, and therefore I went to get it.
I understand. But when you say you found out this existed, you cannot tell the court that the portion that you just watched was broadcast ever at any time on the news. By radio, television, or internet streaming.
Yeah, I just don't want to represent something I can't absolutely remember. I just can tell you I got notice that a statement had been made. I can't tell you that I watched it on the news or that I clicked it off of a news. I can't tell you that.
And Your Honor, the reason I'm assuming that 38111 has this requirement is because it is assumed that the news has gone through their editing process and in their process. What they're putting out to the public is reliable. But the problem is that this has not been shown. It does not purport to be a news broadcast. It purports to be just an interview. The way it would purport to be a news broadcast, just the item itself, because that's what we're talking about, almost the cell phone.
State, is there a news broadcast that is consistent with this video?
So my questions that I was going to ask him is how he came about requesting them from that particular news station.
He says he doesn't know. He says he just went and got it. He got notice and he went and got it.
And that would mean that he became aware at some point, I guess circumstantially, that he became aware that there was a broadcast where she gave a statement. Now, as far as, and the court pointed out, there's not there's something that Mr. Goss is adding that, well, we have to know that that particular portion was broadcast. That's not what the code requires. The code requires that this statement was given to a news reporter and a portion was broadcast, which we know that the only way that he discovers that there is a statement that exists is that he has to be aware that a broadcast happened to a news station.
So I have already ruled that this is admitted. I'm not changing it. I do believe it is authentic, and there is no other issue with authenticity. It is a broadcast.
Well, in Your Honor, I guess, and so we're clear, and so the objection's made for the record that, because I'll just say, I do not think it ever was. I don't think that this statement was ever put out to the public. I think that this is something that was just in the newsroom. And that's it. And so the problem with that is that what I understand the court's ruling, but what Oscar just said is he said that if a part of something is broadcast, you can play any of the raw footage from everything. And that's not what the rule says. And we don't even know what part was broadcast. The rule is if you want to play this statement in court, this whatever this is, you have to show that this statement was a broadcast statement. Otherwise, if that statement wasn't broadcast, then the authenticity can't be purported to be a broadcast. And so what I was saying about being on the face of the statement is, it would be easy for us to say, yes, it's purported to be if you could see it as part of a broadcast. So the news, let's shoot it to this reporter, and then and it's got all the cryons and everything else going on it. I'm just saying that on the face, I'm not saying it's required, but on the face of it, we could at least see that it purports to be a broadcast and not purports to be some interview or some statement that was made at a time that was never broadcast out. It's just the broadcast portion of the rule, and I did not know, before you made your ruling, I was focused on the other part of it, but I was not able to focus on that part of it. And so that's why I'm asking you to revisit your ruling, because I didn't effectively argue it in the first place on that issue. And so now as we can see it, that's why I wanted to put that on the record, that's why we're objecting to the authenticity. And nobody is so far has testified that portion was broadcast, and it is required in the rule that it has to purport to be a broadcast somehow. He can't do it. It can't do it on his face. So that's what we're left with.
Well, how did you all come to get this item of evidence?
Brandon Freeman can tell you that.
So, I had to have seen something in order to know that it existed. I just can't remember exactly what I saw. I'm sorry. But I can tell you I know of a statement that had been made.
By the constable.
Exactly, yes, ma'am. And then I made it known to the attorney. I think she made a statement. I consider it a witness statement. Let's see if we can get it. So we did. We issued a grand jury subpoena and we got it. I can tell you it wasn't just...
Was there a business record affidavit attached to this submission?
I mean, even academically, Judge, I'm thinking of argument outside of this 38-111. 3-1-1. It's still nevertheless a statement from the defendant, by the defendant, regarding facts about what happened with Rodriguez Park. It'd be analogous to if Ranger Freeman came across a flash drive, plugged it in, and found out, oh, that's actually a statement from the defendant about these facts. As far as whether again, all that would go to the weight and not the admissibility of that statement itself, because it is her statement.
But 901 and 902 would require, even if you had a statement to a police officer, you still have to have a police officer say that's my authenticated. And right now, they're trying to rely on self-authentication, but the portion that says if you want it to be self-authenticated, it has to purport to be a broadcast.
Okay, so this is what we're going to do. I am going to let you continue with this cross-examination because this video is not an issue with where Dawn is on her, direct examination. So I want to get at least an hour of testimony in so then the jurors can go to lunch. Let's do that, and during the lunch break, follow up on my request. Was whoever submitted this to you, was there a business record?
Yes, Your Honor, and can we just ask the state to point us to it? Because since Ranger Freeman references subpoena, we'd like to see, we may have it, but if we could just find it quickly so we can see the wording. Did he ask for the broadcast or did he ask for the raw footage? And that may also enlighten us as to exactly what they said.
I'll have to pull it up on my computer.
I want to move on to the direct examination. Oscar, you also need to mark and identify the unredacted portion. And then defense, you still owe me your 14, which is your part that you wanted to offer as optional completeness. So those matters are outstanding.
Can we take 74 out of it?
Yes.
Your Honor, I have actually have seen it, so it does ask for the raw, but it's not the broadcast footage, the subpoena.
So you found it?
I did, I found it on the computer. So that, he is asking for the raw footage, not the broadcast footage in the subpoena, that's what he got.
And just for the record, you requested it from a news agency, right? A news organization.
100% I agree that this is from a news agency, but the rule for self-authentication requires it to be broadcast first. It purports to be broadcast. It's just-
Well, isn't there a business record affidavit that can self-authenticate it? If authentication is the objection?
I do not believe it was filed 14 days prior, but
So we will cross that bridge at lunchtime. We're bringing the jury in now.
yes, sir. Your Honor.
So you just want me to skip this whole part?
Related to the video? Yes.
Okay.
You can move on to other areas until we can get to lunch. Oscar, the unredacted will be 75.
35.
All rise for the jury.
All right, good morning. Welcome back. We're going to continue with the direct examination of the ranger.
I believe where we were yesterday was working on the timeline, so don't get too far behind. So the last entry is June 19, 2019, Ranger and FBI Special Agent Rivera meet with Susan at FBI to provide 2 statements. And those 2 statements you're referring to are what? Were they the drafts? I believe they're already in evidence.
Yes. We talked, they're different from mine and yours. Not really different, but yes, she gave a copy of both statements that she was asked to give by the constable.
So the next step in the timeline was the recordings. So, and we've already had that stipulated too, that they were the dates June 25th, 2019 and June 26th, 2019. Did I have that correct, Defense?
Ma'am?
Did I just state the dates correct that you stipulated to, June 25th?
To the wire?
Yes.
Yes, ma'am.
And in your report, we were moving into July 1st of 2019 on 9.1 in your report.
Okay.
What more materials did you receive related to this investigation?
That is when I met with Officer Olivares, and he gave emails and other reports related to his interaction with the constable at Rodriguez Park.
And did you interview him at that time? Or did he just provide documentation?
He just sent an email.
I see.
That included his statement, so there was no interview.
So what date, later on in July, does something else occur?
All right, so after the 1st of July, after a meeting with Olivares,
Skipping forward to
yes,
11.1.
skipping that one, we meet with Susan again.
And what was that purpose?
We provided her with a recorder on 7/24. We also set up to where we would interview her that day.
Does she provide any documentation at the time of your interview?
She did, yes.
What did she provide?
She provided some additional cash logs. I have noted.
What are you doing this one? Making a mess of it. Your Honor, is the next state's exhibit number 75?
76.
Mark the state's exhibit 76. Do you recognize this?
Yes, I do. These are cash logs that were given by Susan.
On July 24th, 2019?
Yes, ma'am.
Your Honor, these have previously been admitted in another exhibit. However, I'd like to admit a State's Exhibit 76 as being the one she provided that day. You know what, Your Honor, I'm just going to withdraw this offer of this exhibit.
Well, let's keep it marked. We'll just return to it whenever you're ready to offer it again. Okay, but don't withdraw it. We're going to, the next one will be 77. Okay.
So there were several times that Susan provided copies of cash logs to you, is that right?
Yes, sir.
And did you subsequently determine that they're the same cash logs that we went through under the state's exhibits that have been previously admitted as 31-2-4, -5, -6, -7, -8, -9, -10, -11, -12, -13? Hold on. -11. Yesterday, we had gone through those, and we went and showed the difference between the two.
Yes.
Are those the same documents that she kept providing you?
Yes, they are.
Okay, so I want to go through those yet again. So suffice it to say that she was providing you copies of the cash logs.
She was.
And the cash logs, there were both versions of the cash logs that are that predated the grand jury subpoena, and then the one handwritten logs.
Yes.
And then also the handwritten logs that were in the handwriting of the defendant? The ones that are, well, I guess you might not know the handwriting of the defendant. Let me show you those. I'll just show you one example of the page just for your familiarity and what we looked at yesterday. State's Exhibit 31-2-9.
I remember seeing that, yes.
Okay, and so actually the jury already knows that these are the handwritten logs. So I want to keep going on with that. When was the next step in your investigation and what did you do?
John, you don't want me to go to the next,
Let me
do you?
Your last answer was July 24th, so that was the next answer.
Yes, but
Hold on one moment, please. This is a big document here.
yeah, so if I go to 12.1, I can't.
No.
Okay.
No, I want you to time to... August 29th of 2019.
Okay. Yes, 16.1?
Yes.
Right. All right. Very well. We met again with Susan. Susan once again provided some documents. I have noted here we received additional cash logs. I also have noted a conversation we had with Susan.
And so those same cash logs that we've just been describing, you received copies of all or some of those?
We did. We received some more cash logs, and we also received.
Let me show you.
I'm just not real sure about the
Yeah,
next
I
one.
understand.
Okay.
We're gonna. So you received just more cash logs, more interviewing of this. Did you interview her at the time?
Yes, we did talk to her again.
And was it you gleaning just more of the same information from before?
Yes, ma'am.
Okay. And then when would the next time you met with her be after August, or if you did, I'll say if you did meet with her again after August 29th of 2019?
I just want to make sure I don't miss anything.
That may very well be the last time we met.
I got a feeling it is.
Okay, that's fine. So let me write that out on the... August 29, So, after this point, what is the next step you take in your investigation? We're going to go back to all the grand jury subpoenas, but at this, I'm just trying to get a chronology. What is the next step you take? And on what date?
As it relates to Rodriguez, or what's next?
As it relates to the warrant date. You've already previously testified to that.
Yes.
And so I just want to put the date.
Oh, okay.
I just want to get them up here on this timeline for the jury, even though you were the first witness they heard from. So I want to just request the memory of what you stated about when the warrant was executed.
Okay. If you ask, I guess I'm okay.
Just what date was the warrant executed?
Yes, ma'am. We received the warrant on the 20th of September.
Okay. And what do you mean by receive?
We got it signed by a judge. And we served the search warrant on the 23rd of September.
I'm just going to put SSW for search and seizure warrant. And then you executed on 9/23. And then after the warrant was executed, what date did you work with the evidence that you recovered in a document format? I believe that's 20.4.
On the 30th of September, myself, you, and another investigator began reviewing everything that was gathered at the search warrant.
And were you doing anything with the documents you were pulling out of the evidence bag?
Yes, we as we pulled them out, we scanned them. And yeah, we saved copies for scan and placed them back in their bags.
Do you remember the investigator's name?
Scott McNaughton?
So subsequent to that, related to this investigation, did you interview any more witnesses?
Related to this investigation, yes.
Okay, as it relates to this investigation, when was your next witness interview and who was it? I believe it's somewhere around October.
Yeah, October 23rd. That's what I'm keying on, but I went back just to make sure. On October 23rd, myself and my FBI partner, David Rivetta, we interviewed Precinct 2 deputies Wayne Dennis and Vanessa Pena.
And did you obtain statements from them?
We did. They're recorded interviews.
And When was your next interview and who was that? I think it's in 25.
On the 30th of October, I interviewed Precinct 2 Deputy Tony Cardona.
And did you take a statement from him?
Yes, ma'am.
Now, I don't know that I can't tell if it's reflected in your report or not. Did we interview other individuals from the precinct, but no statements were recorded from the administration staff?
We did interview Castillo in the presence of his attorney.
And who else?
Jeremy Minor.
And was that also in the presence of his attorney?
Yeah, they're not our clients, but that's inappropriate that that's their attorneys.
Did he have his attorney present?
Yes, ma'am.
And was I present?
Yes, ma'am.
And no recordings were taken at that time?
No, ma'am. Sorry.
And at some point in time, did you and I meet to go over all of the evidence and investigation that you required?
Yes, ma'am. November 22nd, we met and talked.
What year?
2019, excuse me.
Do you recall when the interviews were of Castillo and Minor? I don't know that they were noted.
When they were?
Yeah, when they were. I don't have it down, so I don't know if it's been recorded or not.
Yes, so Minor is November 21st.
And Castillo?
Did we talk to Castillo?
Yes. It might have been. You know what, I think I didn't mark it in my report of your copy, so I can't correct you.
Yes, I haven't run across anything listing where we talked to Castillo.
Okay, that's
Judge, I'm
fine.
going to object to this conversation they're having in the testimony.
I understand, that's overruled.
Okay, let me write those dates on the timeline.
appropriate.
So, September 30th, 2019. So would it be correct that you just stated the next thing you did was on October 23rd, 2019, you interviewed Vanessa Pena?
Yes, ma'am. Vanessa Pena and Wayne Dennis.
And then you stated the next date was October 30th?
October 30th is Tony Cardona.
And then, you know, at least the date for during the minor's interview is November 21st?
Yes, ma'am.
And what is your recollection as to the time frame that Anthony Castillo was interviewed related as to during the minor's interview? Was it near in time?
I just don't remember.
Okay, that's fine.
I think it's safe to say it was after the new administration, however.
So sometime in 2020? Well, I don't want you to guess. It's just, I'll just write it down that an interview occurred.
I'm sorry, Don, I can't hear what you're saying.
I don't want him to guess, so I'm just going to write it down that an interview occurred. I won't have a date next to it.
Thank you.
And then what was the date in November you said that you and I went over everything?
November 22nd.
And I'm just using my first name on here since we've been using my first name through this whole thing. Everybody knows me as Dawn, so. Now I'm going to go back to when the grand jury subpoenas were issued. I'm going to hand you what's marked as State's Exhibit 47-1. 47-1. It's previously admitted into evidence, a grand jury subpoena. So what date was that signed by me?
This was signed by you on June the 11th, 2019.
So I'm going to put a red box around the June 11, 2019 date where Ranger served first grand jury subpoena to Constable. So that happened on the same day. Is that correct?
Yes, ma'am.
Okay. So what day was it due?
Due back June 26, 2019.
I'm going to draw an arrow with the date June 26, 2019 and put the word due. I'm going to hand you what's marked as State's Exhibit 47-2, previously admitted into evidence. This is another grand jury subpoena, and just, in a word, what is it for?
It is for items related to Rodriguez Park.
Okay, and what date was that issued?
June 26, 2019. No, excuse me. Sorry. This was signed by you on June 25th, 2019, Don.
Okay. Can you, with more specificity, add the description for what you were asking for Rodriguez Park, as stated in that document, since it's in evidence?
Yes, ma'am. Please provide any audio or video recordings in your possession for Rodriguez Park that depicts any employees of Rodriguez Park, any audio or video captured by your agency or provided to you by a private citizen taken at Rodriguez Park, or any audio or video that depicts or is said to represent Bexar County employee Henry Guerrero. Provide identification of persons submitting evidence to your office describing any employees of Rodriguez Park to include Henry Guerrero.
I'm going to hand you what's marked as State's Exhibit 47-3, previously admitted into evidence. What date did I sign that grand jury subpoena?
This was signed on the 18th day of July.
And what was it for?
I'm just going to read it.
That's fine.
Please provide any case reports, incident reports, investigative reports generated or provided to your office related to Rodriguez Park. All reported investigative assignments for deputies directed by Constable Michelle Vela and or any self-initiated investigative reports dealing with Rodriguez Park, located at 2060 Rodriguez, San Antonio, 78227.
I'm having trouble up here spelling correctly. And I'm going to hand you what's marked as State's Exhibit 47-4, previously admitted into evidence. When did I sign that one?
You signed this on August the 20th, 2019.
And what was it for?
And underline in bold, please provide security records and deputy police officer assignments and schedules related to the security for Rodriguez Park for the period of time beginning January 1st, 2017 through the present time. Specifically, any documents displaying the names of the officers and the individual dates, events they were assigned to, along with any other related information, such as the time, pavilion location, hours worked, compensation received, etc. If such documentation does not exist, please provide an absence of business records affidavit.
I'm going to hand you what's marked as State's Exhibit 50. This is previously admitted into evidence. Did you receive this in response to the subpoena you just read?
Yes.
And what does it say to refresh the jury's memory?
This is a business record affidavit. It has Susan Tristan's name on it, and under it says no records other than those produced.
And what date is this signed?
August 28th,
Of what year?
2019.
Thank you. I'm marking a red box around the 820 and 828 entries. Get a little messy. I'm going to hand you what's marked as State's Exhibit 46-2, the 211-page document. It isn't in evidence yet. Can you just identify it for purposes of the record?
On top here is the original, very first grand jury subpoena that we issued.
And is your handwriting on that, actually? Is that your handwriting?
No.
No, that's not. Okay. And that's referring to the June 11th, 2019 grand jury subpoena?
Yes, it is.
And you just described that it's actually attached to the top of that?
Yes.
Okay. And do you recognize that as the documents that were in response to that grand jury subpoena?
I do.
Can you see the attorneys up here, please?
Question, who did you get this from?
From you.
St. News to admit.
So we're just trying to confirm, that's all.
That's fine.
No objection, Judge. Pursuant to what our previous discussion was.
What number is that?
It's 46-2.
Yes, that's submitted.
On that hand, what's marked as State's Exhibit 40. Do you recognize that document without saying anything about it?
Yes, I do.
And what type of document is it?
This is a copy of an email.
Throughout the course of this investigation, did you have occasion to communicate directly with Constable Vela?
On this one occasion, yes.
On this occasion?
Well,
Or-
and then after I served the original subpoena, we had a phone conversation.
Okay, so did you have an occasion in any form of communication, whether it be email or otherwise, to discuss the grand jury subpoena of June 11, 2019?
Yes, ma'am.
And in what form was that?
It was via email.
And what date would that have been?
Judge, excuse me, this is July 2nd? Don't,
Yes,
no objection to this.
okay.
July 1st. The reply was July 2nd.
So what exhibit number is that?
40?
40, stays exhibit 40.
State's 40 of it.
So the way emails work, it sort of goes backwards, right? It has the reply first and then the initial sent message below.
Yes, ma'am.
Okay, so I would like you to read the date of the message that began the conversation.
Okay. Sent by me on the 1st of July, 2019, 3:56 p.m. The subject says Rodriguez Park subpoena. The body of the message is Constable Michelle Barrientes Vela. Upon receipt and review of your response to the Bexar County Grand Jury subpoena dated 6/11/2019 for records related to Rodriguez Park, I have noted the following. The lack of names for deputy constables who were assigned to work Rodriguez Park events. The lack of corresponding security agreements as compared to receipts and park reservations scheduled through Bexar County Parks. Was this an oversight, or do these records not exist? When we first spoke after my delivery of the subpoena, you gave me the impression you had a list and or a schedule of deputies who were assigned to work. I recall you saying you and your chief deputy worked most of the events.
And then can we move up to her response and identify who responded to you and the date?
Date reads Tuesday, July 2nd, 2019 at 10:09 a.m. Freeman Bradley. At one point, most of the deputies, excluding a small amount within my office, have worked part-time, in parentheses, side job not pertaining to Bexar County, at Rodriguez Park, including myself and Chief Castillo. The clerk within my office has provided the documents she had. In turn, I handed them to my attorney, who is representing me, in parentheses, not a county attorney, to hand the Bexar County District Attorney's Office last week. To hand to the Bexar County District Attorney's Office last week sometime. All information has been provided already to the Bexar County District Attorney's Office. Also keep in mind, my clerk made an affidavit which was included with the document. Thank you, Constable Barrientes Vela.
May I publish to the jury, Your Honor?
Yes.
So the first thing that I placed up on the monitor is State's Exhibit 46-2, just admitted into evidence. It's the 211-page document that you just testified I gave to you.
Yes, ma'am.
And you noted the requested information, and there's been previous testimony about what a deuces tecum is. And so I'm pointing to the area below the deuces tecum. What would you describe this paragraph as?
And that's the request. That's what we're looking for.
And in your request, it appears to have different font sizes and different font colors. So could you please describe the differences?
Well, the one in red, if that's what you're referring to, is because we knew it existed. So I just wanted to make sure.
And you knew it existed how?
Because I got it from the parks and recreation folks.
And that was that security agreement?
Correct.
Okay. And so what were you attempting to gain by requesting these documents?
I just wanted to make it clear. And we just, there was an inquiry. We wanted to get as much information as we can so we can lay out facts.
And in this description, you've asked for deputy work assignments and schedules.
Correct.
You also just read an email that further discussed that.
Yes.
In your email, you related that a conversation when you served Constable Vela with the first subpoena, this one, you stated she gave you an impression. Would you please elaborate on that impression?
Well, when we talked, she told me that mostly my chief deputy and myself work these things. You're not going to get much. I have to.
And so in anticipation of that request here, what were you expecting to get returned to you?
Right, so I was obviously expecting to get Rodriguez Park security agreements because I had it in my hand. I knew it existed. But included in that agreement is the time, date, and the deputies that worked it. So I was expecting to get said records, including the deputy work assignments, schedules related to security contracts.
So at this time, when you served her with State's Exhibit 46-2, did you even know the existence of the cash logs?
I can't say I did.
So you were not able to identify them as such by name?
Right.
And so, having gone through State's Exhibit 200, the 211 pages, I'm going to flip through some pages, and you can just describe what it is that it's contained. I don't want to go through all 211 pages.
Yeah, of course.
But so I'm flipping through some of the pages. What would you describe that as?
That's a security agreement.
Okay, and then, and this format appears to be one type of format, and then I'm flipping to the next page, and that appears to be a different type of format.
Right.
Okay, so there's two different formats.
Right.
And then there appears to be other types of documents contained herein, or what would you describe this as?
I would imagine that that's kind of a work product for whoever's in the office taking down notes on who, what, when, and where for Rodriguez Park.
So there appears to be a lot of security agreements in here.
Yes, they are.
So another type of document that appears to be in here looks like emails, and then there are grids that look like excerpts from spreadsheets. What would you describe those as?
That's a spreadsheet that looks like dates and times where Rodriguez Park was used and who used it.
And then are there numbers of emails as well?
Right, so, much of that is coordinated through the Parks Department, and so they would be communicating back and forth, so that's included in here.
Okay. And then there's other types of documents. What would you describe those as?
Those are receipts.
Now, there's this document that's a little hard to read. The copy's very dark. I'm going to hand it. This might be too hard for you to read. I'm going to hand it to you and see if you can read it out loud.
So from what I can tell, it has Chief Castillo on the first line. It's some type of spreadsheet. It says Park, 7:15 a.m. I want to say that date's 4/21. Then it has Constable David Pena and Deputy Cardona. And Park, 4/21/2019, 4 p.m. Okay, so let me get back in order here. Chief Castillo, 4/21. It just says Park, 7:15 a.m. to 1 p.m. Constable, 4/21/19. I'm going to say that may be an abbreviation for Rodriguez Park, 7:15 to 1. Deputy Pena, 4/21, 4 p.m., 10 p.m. Deputy Cardona, 4/21, 4 p.m., 10 p.m. And hang on, Don. Yeah. Oh, here we go. So what I can make out is it is a I think it says Easter officer time record.
Okay.
That's what I think it says.
I'll put it on the monitor. So, yeah, without getting that out of order. So, you just read Easter officer time record, and then from what you can tell, this states, it lists 4 individuals, Castillo, the Constable, Pena, and Cardona. They worked on April 21st of 2019, R Park, which you believe to be Rodriguez Park. And then it gives the times, and the times being for Castillo, 7:15 a.m. to 1 p.m. For the Constable, 7:15 a.m. to 1 p.m. For Officer Pena, Deputy Pena, 4 p.m. to 10 p.m. And for Deputy Cardona, 4 p.m. to 10 p.m. Did I say that accurately?
Yes, ma'am.
And then there appears to be a few more documents as it relates to Rodriguez Park. What would you describe that as?
It looks like maybe kind of a rule book stating the rates and things of the park.
Okay. And,
Yes, there it is.
okay, so,
Terms and conditions.
okay. And then it appears to be some blank forms.
Right.
What would you describe that as?
It looks like something they would use to close out to kind of rate their experience at the park.
Okay. So next I'm going to be placing on the monitor State's Exhibit 40. That is your email between yourself and Constable Vela.
Yes, ma'am.
And you've already read it all. Your Honor, I could be at a breaking point now if that's a good idea.
Yes, I was going to ask. Break. Ladies and gentlemen of the jury, we're going to break for lunch. You remain under the same instructions. Let's reconvene at 1:30, please.
All rise to the jury.
Regarding State's Exhibit 74, the statement to the news media, I found that broadcast online. The court would like to take judicial notice, and I can play it for the court.
Can you show it to opposing counsel?
Right now, IT is taking over the computer because I couldn't log out. Okay.
What time will come back inside?
Ish.
It's just hard to issue.
One-
I think it's Alex or Eric. He let me know.
I'm sorry, I missed what time you said to return.
1:30, but defense needs a little more time, so I said 1:30-ish.
So I'm gonna release the ranger to go to lunch,
Yes.
1:30-ish.
I don't go anywhere. I'm here. Like, I'm ready to start at 1:30.
court to admonish the witness. There were several times on direct examination where he referenced, you don't want me to talk about this next portion, right, Don? You don't want me to talk about this here, do you? Or this investigation, or this, really emphasizing that to leave a, I can't speak for his intent, so I won't do that. But it could leave a false impression to the jury that there's something else. I think it's very clear, and I believe Jason spoke with Don or Oscar, one of them, that Don nor Oscar is going to ask about anything other than Rodriguez Park. So there should not be a question of what you're asking about. I think there's clear pre-trial, during the trial, and again, we strategically chose not to object during that time, but I want to put everyone on notice, and I'd like the court to admonish them. Please, Judge.
And Your Honor, Mr. Goss and I did talk right before the lunch break, and he spoke of the same thing, and I did relay to him that the difficulty it is to know when this investigation is reduced down to a sentence or two within a big paragraph, and he's trying to find what he's allowed to talk about as opposed to what he cannot talk about. So there's going to be hesitation. Mr. Goss said he's okay with the hesitation. The ranger and I have already spoken about trying to limit any indication that there's something else. We're doing our best. I did say that I've had to resort to leading him because in order for me to direct him to the permissible statement, I've got to direct him very much so as a leading question, because otherwise he could easily go into something else. And Mr. Gostin said that's the reason they're not objecting.
Right.
So,
thank you.
Right, and I'm allowing it, and I understand all that. He has a 94-page prosecution guide he's going through, and I want him to stick to Rodriguez Park. So I think we're all on the same page on this, Ranger Freeman. Just the only advice I have is pause, count to 3 before you start answering. That way, don't be in a rush to answer, okay? I'm not in a rush, so don't be in a rush to answer. All right, anything else?
Yes.
Shall we take up the video now?
Yes, I do. The state has, since this topic is being discussed, the state has another matter. It might be a little premature, but...
Well, let's take up the video. The video is, I've already admitted it.
It's where I'm handing y'all the motion with regards to closing and cross-examination, and I can address the court after I play this video. So this is the broadcast that was from June 20th of 2019, which was a Thursday. News for San Antonio by Matthew Seedorf.
News for San Antonio?
Yes.
From what day?
June 20th of 2019. Can I play it?
Yes, I'm
News
also
for San Antonio's Matthew Seedorf met exclusively with the Precinct 2 Constable about these new accusations against her office regarding the arrest. Matthew.
Tonight, a lot of finger pointing regarding what happened at the jail on April 30th. We were there unaware of what happened before the arrest. It's just another form of retaliation. Check the court records. A normal arrest or a parade for the media. Deputy Constable Michelle Barrientes arrested in April, accused of falsifying untrue official documents, a felony under Buffalo. Elsewhere, charges dropped hours later by the district attorney. This is another form of retaliation from the This video we obtained from inside the jail shows what Barrientes' attorney calls unusual events. The client under arrest back in this SUV for booking, but then they reverse and leave. 17 minutes later, Marino reappears, this time outside in front of our camera.
We'll ask Dr. County Sheriff's location.
And just showing it before the court, the defense counsel, it's the same interview, it's the same parts of that interview that were.
It's not gonna change my ruling. I've already admitted it.
Does this satisfy the court? May I stop playing?
Your Honor, I don't know that it was admitted yet. You had said your ruling, and then I came back and reapproached based upon that issue before there was submission for the document.
Right, but I was satisfied it was a broadcast before you specifically argued it on the record. So now you have had a chance to specifically argue that objection on the record. That objection is overruled. That has already been admitted.
Yes, Your Honor. And so could we just have, because I haven't seen the whole thing, but I think that I think it will be an important issue in fact if what they're actually going to play was part of this broadcast. And so could we have it, I don't need to watch the whole thing if they'll stipulate that what they're playing was not part of this broadcast and wasn't broadcast.
Right, I mean, The whole 5 minutes of it was not on the broadcast. I mean, it's a broadcast.
Or any portion of it. Was any portion of what you're going to play on the broadcast?
Yes. Didn't she just say we were asked to provide security on that broadcast?
No.
Then I didn't hear the whole thing.
As law enforcement, as all law enforcement, you have the right to go ahead as our office, any other office, to use word in media, which we post all the time.
According to Moreno's attorney, as a result of a telephone call, Mr. Moreno was taken back on the street. The arresting officers drove around in the jail until he assembled. He was taken into the facility in a way that exposed him to maximum incarceration.
Is there possible connection? I don't know. But I think there's some one sentence part, not just my office.
Barrientes Vela and Moreno have a past including accusations by Moreno that the constable tried to touch and caress him, something she denied in a recent interview.
Those are his allegations.
So nothing happened in October.
So, that's it. Yeah. So,
This year, Moreno filed paperwork to run for the constable position in 2020. More controversy in an already messy relationship.
That just sounds like something after. That doesn't sound like Easter.
No, yeah, it's not, so, but it's part of, but it is part of that interview, so when he.
The
becomes
first
aware-
part was part of it.
Well, when he becomes aware of the fact that she gave an interview that was broadcast, he then subpoenas the entire interview, which again goes to the authenticity of it because it came from a news broadcast.
I'm done with this. I think I've given you guys an opportunity to make your record. So if there's anything else you need to add for the record?
No,
Yes,
we can move on to the motion.
Well, Your Honor, I do have something to add to the record. It's just, I'm not sure that David was writing down word for word. So if there is a stipulation, and it can be stipulated by the state and acknowledged by the court, that broadcast that was just played at court had not one part of any part of the interview that they are seeking to play in their state's exhibit that was the subject of our objection. And so I guess what I'm saying is what they're playing in court was never broadcast. It's not purported to be broadcast. It was never broadcast, that section, that part of it. So if that can be stipulated that that is true, then I think that the facts will be clear for the appellate court, because our argument obviously is that what that says is that the thing that they're playing has to be purportedly from a broadcast, and it's not. The fact that the broadcast dealt with everything but Rodriguez Park, or that it even came from the same interview, our argument for the record is that the reason that it has to be a purported broadcast is because that's gone through the editorial controls that would allow them to release it in the public, so therefore it can be trusted. In this particular instance, it did not go through those controls, and so that's why.
I don't think that the statute requires all that, Jason. I don't think that what the production team or the editors deem worthy of making it on the TV is exactly what the Code of Criminal Procedure contemplating in authenticity. I don't agree with that. I think it's authentic. It's coming in, but go ahead and make the rest of your argument if you have some more.
Yes, Your Honor, and just to be clear for the court, I'm not arguing this to have you change your ruling. It's just I'm trying to talk to the record and put it on the record what our reasoning is, what we believe our reasoning is, why we believe it's correct. And if we can have a copy of the broadcast entered as not obviously an exhibit, but as a court's exhibit, so that it'd be marked so that an appellate court could later look at that and make the analysis that if she were convicted, that we would ask the court to make.
Yes, absolutely. Let's get a copy of that. You still owe me the other exhibits. Let's take care of that right now.
What exhibits are those?
The full unredacted version of the raw video.
It's
75. So state 75 is only for purposes of appellate record. You can leave it there with David. And that is a USB drive, right?
Yes, sir.
And then I'll need a copy of the broadcast. Let's make that a defense exhibit.
Or it could be a court's exhibit, I guess. But if you'd like to be a defense exhibit, I just wouldn't want to mess up our order if it's not anything that we're ever even going to offer in front of a jury or talk about it. Maybe like court's exhibit 5, I think, maybe, or court's exhibit 4, just for the appellate record.
So the court exhibits go in the district clerk's file, and the trial exhibits go with David. So where do you want to go?
Okay,
The Fourth Court of Appeals will normally not look in the court's exhibits for evidence.
then if we could have maybe use letters for it, defense exhibit A, or I guess we haven't had it A yet, defense A.
Okay.
And I'll have someone from IT give you a copy from the broadcast that's online.
Yes.
And as far as the admitted exhibit representing what can go before the jury, what would you like that state's exhibit?
That one was already marked 74.
And this is the final
The
redacted version.
redacted final version.
Thank you.
And I don't know if the state did stipulate or they would want to, but I would appreciate it if they would, just to keep the record clear.
Oh, as far as the,
That broadcast does not have any portion of what State's Exhibit 74 has.
that's true, yes.
Okay.
From what I saw on that broadcast online, I did not see any portion of the redacted State's Exhibit 74 posted online. And just so that the record's clear that that portion does come from the interview that's on State's Exhibit 75. So, a different portion, yes.
That's fine, yeah, thank you. Judge.
Okay.
And then this may be, just so that we can
Yes, can I take a look at that?
So the state has a motion in limine. This is when for cross and closing argument, and I assume it's okay to have the ranger review. Okay. So primarily, Judge, we have 4 points.
Judge, we read it. Thank you,
Oh.
officer. We agree.
Okay.
I mean,
Can I read it?
oh, I'm sorry, Judge. Yes. Just trying to-
I mean, this is the exact same thing that they requested with regards to prior bad acts that I have already said nobody can go into, so.
Correct. I just wanted to clear on the record not only for cross, but also for closing. So this way there's no questions that are listed or stated to the jury in closing argument that, well, the only thing that they have is just this case in front of you. They did a whole search warrant on the place and all they got was this, and it's just
No,
a
they
big-
can't argue that and you can't argue that. So it's granted.
And I assume you want me to do every effort to get through my direct today? Is that the plan?
There is no way your direct can go past today. That is already cutting it very close because then they would have the exact same amount of time for cross.
And so we're working till 6?
And we're working until we finish with here. Yeah, 6 would be nice. We have to stay later. Stay late. Can I get a clear cut? Or do you have to see the picture? So we
The original bag
no, let's go to 5. Okay, Ranger Freeman, I think you're back on the stand. Let's line up the jury.
They're ready, Judge.
Okay, bring them in.
All right for the jury.
Thank you. You may be seated.
So I believe right before the break, I had placed State's Exhibit 40 up on the monitor, and this represents the July 1st and 2nd email communication between you and the defendant.
Yes, ma'am.
And you read it out loud so the jury knows what it says, and it was basically confirming that those documents you received from me, she acknowledged having handed some set of documents to her attorney.
That's correct.
And based on your inquiry to her, it appears that you went through those records.
I went through those records and noticed what I listed was missing.
Okay. And so at this time, on July the 1st, you had already received cash log copies from Susan Tristan?
That's correct.
And did you make a comparison between what Susan gave you versus what I gave you from State's Exhibit 46-1?
Yes, ma'am.
And what did you notice the difference to be?
That the cash logs were not there.
And I'm going to hand you what's marked as State's Exhibit 31-4-5-6-7-8-9, two-sided document, -10, a two-sided document, and -11, a two-sided document. I would like you to look at these. They're previously admitted into evidence. If they're those cash logs you're referring to as not being provided in the 211 pages.
Yes, they are. Yes, they are.
And I'm going to hand you what's marked as State's Exhibit 46-2-1, a 4-page document. I'd like you to look at it, and do you recognize that document?
I do.
And just as a description, without going into content, what would you refer to that document as?
It's a receipt log. It's a receipt log.
Okay, and related to Rodriguez Park?
I would say yes.
And who gave you that document?
Susan.
Susan Tristan?
Susan Tristan, yes.
And was it during the course of your investigation in one of those meetings that you had with her?
It was.
State would move to admit State's Exhibit 46-2-1, the 4-page document referred to as a receipt log into the Excel spreadsheet.
State 46-2-1, is that better?
May I publish to the jury, Your Honor? I'm placing States 46-2-1. It's entitled Receipt Log, and the left-hand column, if I could have the Ranger Freeman, if you could walk through this with me. The first column is entitled, can you see from there?
I can, yes.
Okay, what's the first column?
Date received. Next to that is receipt number and the amount. And then it says number of deputies followed by a number.
And this appears to be the document as received by you from Susan.
Yes.
And it just flips through these pages. It seems to go on same information page after page.
Yes.
So here we go, more page, and then it ends. And I just want to denote the last entry date. Can you read that?
It looks.
I want to hand it to you.
No, I can read it.
Oh, you can?
6/7/2019.
Okay, and then I just want to return to the very first page and to note where it begins. So what is the first date?
3/21/2017.
And does it appear to be a chronology over time?
Yes, it does.
Now, already 4 grand jury subpoenas as they relate to Rodriguez Park have been entered into evidence. I'm going to just briefly cover 47-2 related to the, you read it into the record and it relates to a video, any video, and specifically a Bexar County employee, Henry Guerrero. Was this subsequently complied with, if you recall?
I believe it was, yes.
And then I'm going to show you 47-3. This is regarding any case investigation self-initiated by the precinct related to Rodriguez Park. Was that subsequently applied?
Yes, ma'am.
All right, thank you. So we'll go to those. Now I'm going to direct your attention to the fourth one, 47-4. So how did it come about that you decided to issue this grand jury subpoena having already requested similar items?
So again, I had in my possession something related to Rodriguez Park that I knew existed. So as to be clear, we issued another grand jury subpoena and we were very specific about what we had asked for.
And what specificity did you include in this grand jury subpoena versus the first one?
Security records, deputy/police officer assignments and schedules related to security. Specifically, any documents displaying the names of the officers and the individual dates, events they were assigned to, along with any other related information.
Now, when issuing this grand jury subpoena, would you believe that the precinct 2 constable would be aware that you were in possession of cash logs?
That's speculation.
So at this point in time, had you had any conversations with the Bexar County Precinct Constable about items entitled cash logs? Yes or no?
No.
So at this time, you are now aware that cash logs exist? Yes or no?
Yes.
And you are aware that after the first grand jury subpoena, you had not received them?
Yes.
And you believe that that would have been responsive to your first grand jury subpoena?
Yes.
And so in having that expectation, did it surprise you not to receive them?
Yes.
And so this fourth grand jury subpoena, which is really the second related to the first, why was it that you came to determine you needed to issue a second for the same thing?
I didn't want to appear to be tricky or overlooking anything. I just wanted to make sure that they knew what we were asking for.
Now, you don't call them a cash log in there.
I don't.
And is there any reason why you wouldn't refer to a document as a cash log? But did you have knowledge of a cash, or were you supposed to have knowledge of a cash log by that time?
I knew about them, yes.
You knew about them, but they didn't. How did you know about them?
Because Susan had provided them.
But not because the precinct 2 constable told you.
Right.
So if you were to name the cash logs in this grand jury subpoena, would that have put any confidential informant at risk of discovery?
I mean, that would be my assumption, yes.
I'm going to play State's Exhibit 47-4. I just want to emphasize what the ranger just read about his specificity in this grand jury subpoena. As you can see, there, it states in the Duces Tecum specifically, any documents displaying the names of officers and the individual dates, events that they were signed to, along with other related information such as time, pavilion location, hours work, compensation received, etc. Where, I'm sorry, you need me to repeat? Where did you obtain that information, that language from?
I got that from Susan Tristan.
And did you rely on the copies of the cash logs to see the descriptions?
I did.
And as a result of this, you have previously testified in a document in existence that, as it refers to in here, if such document does not exist, please provide an absence of business records affidavit. Did that occur in this case? I'll show you State's Exhibit 50.
Please. Right, so on the return of that one, it's a business record affidavit that we talked about earlier from Susan Tristan, and it says no records other than those provided.
So you received nothing further than from the first time?
That's right.
So when you wrote that Duces Tecum description on the second grand jury subpoena, addressing with more specificity, did you believe that should have produced those handwritten cash logs?
Yes.
And were they ever produced by anybody other than Susan Tristan when she met with you early on? Produced. Not discovered, produced.
Can I look again, please?
Oh, sure. At the cash logs?
At the very first,
Subpoena?
the 200 page.
Oh, sure. Okay. I'm handing you marked as State's Exhibit 46-2.
Okay. Can you ask me the question again, please?
Oh, I'm not sure I can remember it. So, were they ever produced?
They were not.
They were not, okay. So the handwritten cash logs that we've been talking about, that's up there next to you, were never produced.
No, they produced a absence of business record affidavit.
So how was it that you were able to recover those originals?
Many of them were given to me by Susan.
Well,
Or
the
some-
actual originals that you're holding in your hand, how did you get those?
The search warrant.
Okay. So let's go to the day of the execution of the search and seizure warrant. Previously, you had stated it was on September 23rd, 2019.
I want to get to it, I just don't want the paper to be on the mic as per the judge.
Okay, no problem.
Okay, yes. Search warrant received September 20th, 2019. Search warrant served September 23rd, 2019.
And do you also have listed your return on the inventory?
I do.
What date is that? I know you previously testified to it, but I just want them to remember.
If you and I are looking at the same, it's 19.5. Hold on. Sorry, was mistaken. Return was filed September 25th.
2019?
Yes.
So that morning of the search and seizure warrant execution, did you begin the day early?
We served a warrant on the 23rd.
What do you recall? What time of day you arrived at the precinct?
Got a suspicion it's on the return.
Okay, let me hand that to you.
I can't say it was early in the morning. Very early.
Okay, in the dark, I assume.
We started in the dark, yes.
And do it's marked as State's Exhibit 29. It's not an evidence, so don't speak from it except for to provide the date in time of the execution. Just to refresh your memory.
Oh, jeez. No, the time we made entry is not listed on here. I would imagine our sign-in sheet may reflect the times we began going in.
Okay, then I'm not going to worry about it. It's just early in the morning.
Yes, ma'am.
We can agree on that.
Yes,
Okay.
ma'am.
Your Honor, what is the next exhibit number?
Your Honor, could you please ask the gallery to be quiet? So what is,
Hang on. So the next exhibit available is 77.
thank you.
And with regards to your request to admonish the gallery, I have asked my deputy to handle it at the appropriate time.
Thank you, Your Honor. So I'm going to hand you what's marked as State's Exhibit 7. Do you recognize that?
Yes,
And
this is
just a description.
the picture of the Bexar County Precinct 2 Constable's office.
And was it that morning?
It was taken that morning.
Okay. And I'm going to hand you what's marked as State's Exhibit 77. Do you recognize that?
I do.
And just a general description.
It is a picture of a receipt book, another document and another document that appears to be related to Rodriguez Park.
And is there a kind of a clear colored binder on there as well?
Yes, there's a binder with other paperwork inside.
Okay. And was this on the day of the execution of the warrant?
Yes.
State moves to offer State's Exhibit 7 and 77.
There's no objection to States 7 and 77.
Those are admitted.
May I publish to the jury?
Yes.
I'm placing Exhibit 7 on the monitor. This is the picture of the Bexar County Precinct 2 office on the morning of the execution of the search and seizure warrant. And then I'm placing State's Exhibit 77 on the monitor. This is what you described as the binder with the receipt book and some document pages on the day of the search and seizure warrant.
Yes.
And I'm just going to hold up what's marked as State's Exhibit 31-2. Does that appear to be the same binder that's in the photograph?
Looks like the same to me, yes.
Infamous purple binder.
Should we object to relevance in here, see on these documents? You can approach.
Yeah. take up the matter outside your presence.
All right, we adjourn.
You can take a break if you want.
Okay.
Yeah.
Item numbers?
Well, there's like a,
No, that's just a marker. The item for all of the photographs is in one folder. All of it's the FBI folder, and then it drops down to photos. These are all within that. I marked these 6 exhibits. And the reason for doing this is when the vehicle was processed, and the defense has made a point of talking about how her policies and procedures regarding how she maintains the records for Rodriguez Park, and clearly it shows in the back of her own vehicle on the day of the search and seizure warrant, she is carrying around Rodriguez Park documents in her visor as well as the back of her vehicle.
We've made a point of that. We didn't say anything about how she did it.
You were saying,
again, Again, these don't have to do with Rodriguez Park.
Actually,
Hang on, I have a question about the search warrant that was signed by Judge Moore. This specifically authorizes items relating from 1 August 17 to present.
present being September 20th of 2020. I mean, 2019, I'm sorry. See, unfortunately for this, that encompasses a broader search than just Rodriguez Park. And I will not use States Exhibit 24 and 25, Marker 6, because it does relate to Leonicio and Moreno. But I do want to go with Markers 7 and 5 because those documents are Rodriguez Park.
But these aren't cash logs, Judge. This is a survey of your experience. I mean,
Well, a lot of
Tell me
documents.
which exhibit you're referring
Sure.
to when you're talking.
So I'm referring to States Exhibits 21 and 20 and 21 refer to Marker 5, and 26 and 27 refer to Marker 7. And then, of course, States Exhibit 15 is just the marker placed on the dash of the vehicle identifying it as hers. And then you'll have placards.
So let's take them one at a time.
okay, which one do you want first, Judge?
15, I think, is the first one. First exhibit of that batch.
You were right, Judge, 15.
All right, so 15 is the photograph of her car.
Yes, Your Honor.
Your objection is relevance.
I mean, yes, relevance.
What is the
Well-
relevance of the picture?
It identifies the vehicle that is being searched as hers. And then it leads into Exhibits 20 and 21. Now, if defense is satisfied with...
Somebody put a vehicle 5.
It's a processing placard for purposes of processing a vehicle by the FBI. Now, the placards also exist in States Exhibit 20 and 21. If you don't want that one, that is fine. I just thought they might want the vehicle, front of the vehicle identified. But that's fine. 20 and 21 is sufficient to me. It also has the placard in the photograph.
But Judge, we have the same objections. If you look at 20 and 21. Well, let's do 20 first, I guess.
Yes, it shows where they placed the placard and then where they pulled out the folder that you see a close-up of in 21. So 21 is a close-up of 20. You can see where they placed the placard, where they found the document, and then they pulled it out and made a close-up.
I see that. But is it Rodriguez cash logs?
I don't believe it needs to be. I think you can see here, it's everything that Susan testified to as to the policies and procedures on how a Rodriguez Park reservation worked.
But that's August, that's after.
It's still relevant to Rodriguez Park. We were still in our investigation at the day we executed the search and seizure warrant. There had been no indictments returned at this time.
Judge, the indictment, as you've said many times before, has cash logs in it. This has nothing to do with cash logs. Outside of the time difference.
The investigation, as we have spoken to many times, is about Rodriguez Park. It's not just about cash logs. We weren't even aware of them at the inception of the investigation. Just because...
Well, let's just talk about the dates, though. The date of August 2019 is after the presentment of the indictment.
No, it's actually... The indictment wasn't presented until 2020. The first indictment. I believe it was
February?
January.
Yeah.
Yes.
Okay.
So that we had an ongoing investigation at the time, which is, and we've tried to limit it to Rodriguez Park. We were looking into it, and we were ascertaining over time the various things, and this is part of that investigation.
I think that the up close.
The first one just shows where it was found. I don't have a problem if you don't want both, but I just thought for purposes of understanding where it was.
She's not charged with concealing that document, number one, and this is hearsay.
Well, she's charged with altering, destroying, or
Cash logs.
concealing
Cash log,
Cash-
only.
That's not a cash log.
Yes, but it was the
It's
investigation.
relevant. This one is relevant. So what's your next objection?
Hearsay, Judge.
How can,
Words on there.
So just for purposes
This
of
is-
the record, what is the photograph I just handed you back?
States Exhibit 21.
So 21 is objection to hearsay is overruled. That's the up close photo of marker 5. That's admitted. All right, this one is sustained as to relevance. I'm sorry, that's 20, right?
That is 20. It's been marked, so it needs to remain here.
So that one's not coming in. All right, what about 15? What was the other objection to relevance and what?
15 was just the placard. We can,
Well, I know, but
we can
that's-
forego that.
Relevance, Judge.
I just was doing it for
And
purposes.
cumulative, because the placard appears in all the other pictures.
That's fine. I'll withdraw that one.
Well, it's marked already, so 15. Are you going to offer it, State?
No, withdrawn.
Okay. What was the last one?
It's
There was one
two,
more.
States Exhibit 26 with a marker 7, and States Exhibit 27, that's a close-up. 26 depicts an image of an envelope in the front of the vehicle, in front of tucked into a visor, and 27 is a close-up of that envelope, which is again Rodriguez Park documents.
I mean, Judge, are the same objections to survey. I mean, it's a survey of how your experience is with it to park, with not a name of anybody that's relevant to this case, nor does it talk about cash logs.
What it does is place the defendant demonstrating in her patrol vehicle are Rodriguez Park documents. These documents do have information on it. You can see that it has an individual, a security agreement signed, dated, and the envelope, just as Susan had described, how it normally would work. And this is part of the investigation and recovering of those security agreements.
Judge, then,
Well,
well,
I mean, I guess.
then this would be, we're not going to waive our objection, Judge. We're still objecting to that, but this one is,
I think it's relevant to explain where this came from, and it was in the visor of the vehicle. You cannot see that is where it came
we
from.
can testify to
Correct.
that.
So, State, I don't want you to, so I'm going to limit what they're admissible for. I mean, if they're responsive to the search warrant, the ranger's going to testify that was in the visor. I took it apart. Here's the bigger picture. But do not go into, see, occupations code violation.
No, we're not doing that.
Okay.
I've learned that we're not doing that.
All right, so 26 and 27 are admitted.
And in front of the jury, do you want me to readmit them, or I just proceed?
Well, that's a good question. I never really thought it has to be done all over in front of the jury. The record is clear. We're having
What was
this
the question? I'm
discussion.
sorry.
If we have to readmit them in front of the
Oh,
jury.
no, I don't think so, Judge. No.
Okay.
It's on the record.
Yeah.
All right.
Anything else before we bring them back in? Does anybody need a quick bathroom break?
Yeah, actually.
Okay. Take a break.
statement of a party opponent. It's also going to be the same information that's going to be revealed in the video. If you want to read that again.
Well, but the paragraph goes into Bexar County Foundation and a lot more details that are not on the video.
Well, the two documents, all of the signatures have been previously identified, and the information below the line are the same information that was previously admitted in the 211 pages. I walked through that with Ranger Freeman. It gives the schedule, the person who's working, as well as the times. And I would say that the top paragraph is a statement of the defendant as a party opponent.
Response?
Yes, Your Honor. It is not clear that it is a statement of the defendant as a party opponent. They had one of the deputies up there and didn't ask her about it, and it could be her statement, or it could be Cardona's statement. It sounds like they are signing it, saying that this is what the facts are, not because their signature is below it, and it refers to Constable Michelle Barrientes Vela in the third person.
Can I see it again?
I think a plain reading of it demonstrates that it's from her.
Well, I mean, that's, if you have a predisposition, then yes, I could see that. But what I'm saying is just looking at the document, it's first of all not clear. Second of all, I mean, it's a neat trick to be like, oh, let's get into this other evidence, and now we're going to get into this one because the other evidence, that other evidence is clearly a part.
Rule of evidence to approach this matter. Additionally, if I'm not mistaken, Susan Tristan did testify that this was placed up there by the constable and it was there for several months.
Well, additionally, if she's saying, well, this is just all the evidence we're about to put in on the video that actually has her saying those things and not a question, then this would be cumulative. And you can't have more evidence over our objection and then say that lets us get into this thing that has already been sustained on our objection. And it's cumulative.
Well, cumulative doesn't necessarily mean inadmissible. I've had to produce documentation that is a repeat just to demonstrate who got it and where it came from. This is
I guess the jury, if I allow this, I was really concerned with that whole Bexar County Heritage did not pay money for the law enforcement security on the agreed dates. So that was, I didn't want that to lead into any other discussion about any other matters that we went to the auditors, the checks, we tore. I don't want to go into that. But how is this relevant to the
to the case.
tampering?
So we know from the witness statements and testimony, from the witness testimony that this was posted after the Easter incident. And we know that the defendant had taken issue with, as we're going to see in this video, that she wanted to have her side of things stated. And so this is like post-Easter media frenzy, trying to figure out what happened on that day. We have Jesus Reyes stating that he paid $300, and we have we also know, based on another exhibit that went in, that Rita Fernandez in Pavilion 2 paid $300. So we know $600 was collected from the patrons who were renting the pavilions. We also know from the testimony of Pena and Tony Cardona what they received. Pena said something around $70, and Tony Cardona wasn't entirely sure, but it could be somewhere around $250. It all depends on what the hourly rate was. And so we're talking about the defendant stating in this document that, as she does in the video, that she, out of her own pocket, paid. She's also stating in the video that she and Deputy Chief Castillo actually provided security to Mr. Reyes.
Doesn't this say for the entire park, excluding the privately rented pavilions?
Exactly.
For personal funds?
That's why yesterday when I offered it, it was for not for the truth of the matter asserted, because we believe that is a false document. We believe that she wants people to think that she paid for everything out of her own pocket, but she...
Well, you can't argue to the jury this is false.
No.
You can definitely say, look
Right.
at all these different statements, right?
But this is my reasoning behind why the document is relevant.
Well,
And so this document is in direct contradiction to the testimony that the jury has already heard, where Tony Cordona and Vanessa Pena worked pavilion and only pavilion work. Now, this is stating that she paid them out of their own pocket, out of her own pocket, when we know, in fact, the only monies that Cordona and Pena should have received should have come directly from Mr. Reyes and Ms. Fernandez from Pavilion 1 and Pavilion 2. She's stating that further that she covered their $228 for the county security that was provided that day, when in fact both of those people testified they did not provide that kind of security. This is a direct contradiction of that and how the payments went that day and who paid whom.
if I may respond. Well, first, you know, what this is, what they're trying to do is like, it's a specific instance of conduct first that they're trying to offer to show that she didn't tell the truth. A specific instance of conduct to show that she didn't tell the truth is what we argue that even shows that. But that's what they're offering for. That's what she just stated to you. We're far afield at the tampering because this doesn't have anything to, you know, if she had said also, and I think Nelson Wolff is a huge jerk. Well,
actually, I think she did say that in the video.
I'm sure she did. But here's what I'm saying. Why do they get to get into Nelson Wolff's a huge jerk? Why do they get to get in whether or not it's true that she paid for security or not? She hasn't gotten on the stand and testified to any of this. They're not rebutting something that, like, if she got on the stand and said, I did this. Now, what they're trying to do is they're saying, no, we want to put in a video. And then once we put in the video, we want to show that this is not true and this is not true and all this other stuff. But specific instances of conduct of somebody not being truthful about something else, and without conceding that she wasn't being truthful, but a specific instance of conduct of somebody not being truthful about some other matter or some other thing is not relevant. And so then and they can't get into it, honestly. I mean, it's, you know, under the character rules. But also they, you know, under 403, it's like, what is the probative value of these things? They want to point at her and go, oh yeah, and she wasn't telling the truth about her using your own money in this thing. Well, nobody's alleging that she that she tampered with these cash logs because she used her own money or didn't use her own money or anything else like that. It just doesn't go to what we're here for in the indictment first. What we're disputing about is that in their own records, they just presented that the 4 people assigned to do the entire park security for that day was Michelle, Castillo, Pena, and Cordona. Those were the 4 people that were assigned to do all of that. That's who was there to cover the park. There's nobody else that was there to cover the entire park security. Nobody got paid for working the entire park security from Bexar County. And that's, I guess, not a dispute.
Actually,
entire park security from Bexar County, not the pavilions. Entire park security from Bexar County. They didn't get a check from Bexar County. There's no dispute that they
Those 4 people you just talked about.
Those 4 people, right. Those 4 people in that, there's no dispute about that. And so, I mean, that's where it goes to the other thing of, like, they're really trying to do, it's a side issue that's not actually a main issue. It's a side issue that they're trying to, you know, disparage her character and say, oh, well, look at this too. And she said she paid for these people, and we can show that she really didn't, or added up or whatever, but that doesn't go to the tampering.
this directly relates to the investigation of Rodriguez Park, and in particular, April 21st of 2019. It demonstrates that She's, by that document, by her own statement, she's stating that out of her pocket, she covered security for all 4 of them. We know that that is not true because we had the witnesses testify and they only received a certain amount of money and they only worked the pavilion. Therefore, they were paid out of pavilion money.
Well, so first of all,
That part has not been established.
that's right.
Well, they only worked the pavilion, and there were 2 customers that paid money. Therefore, that is who the money should have gone to per their
Well,
rules.
what I'm saying is, if you want to argue that to the jury, that's different than saying that was established by the evidence. If you want them to make that reasonable inference and you want to, that's different. But
But
that
also-
fact alone has not been established.
Well, but also,
I think
this,
anybody knows.
this says that they were paid for the overall security that the county was going to cover, and we know that that is not true. They said they worked the pavilions. They never worked overall security.
Well, regardless of,
Well, the witnesses did say pavilion.
they talked in specific about the pavilion, but at the time, there were only 4 people there, and all 4 people were there. Vela, Castillo.
No, all I know is Vela, Cardona, and Pena. I don't know anything about Castillo.
Well, once,
Nobody has said anything about Castillo.
well, and since you have admitted the state's exhibit with the video, you'll hear about that on the video because she references that as well, that Chief Castillo was there. And it's in evidence in the 211-page document that he was one of the 4 deputies assigned to be there at the park. Now, if what the state is failing to remember, or I guess maybe have thought of is that they had not scheduled anybody for Pavilion 1 because Pavilion 1 was not supposed to have any security there at all because Jesus Reyes lied, according to their
Again,
witness.
something you can argue to the jury.
Exactly. So I guess what I'm saying is that they were not nobody was scheduled to do Pavilion 1, so they were not assigned to do Pavilion 1.
So I'm going to hold on to the ruling. I know I told you that I would admit it subject to the redaction. That's still my gut instinct. I think this is different than the broadcast. So I'm going to see how you develop the testimony leading into this. I mean, are you just offering it under a different exception, or are you going to develop it some more with this witness, or?
I'm offering it as of yesterday for not for the truth of the matter asserted, and I'm offering it as a party opponent statement.
Right, which is an exception to hearsay as to that paragraph. So
If the court finds
I'm
that
not-
that's the opponent party.
Right. I'm doing, the video is different. The video to me is different. It specifically references Mr. Reyes. It's a broadcast. It's different from this.
Your Honor, we would, and now that we've kind of gone through this argument, and not only for the record purposes, I understand what your ruling is on the video, but we would apply, I wasn't able to make that objection at the time, and I didn't clearly make that objection to the court, and it hasn't been shown to the jury yet. So the video, what they're trying to use it to prove that she paid out of her own pocket to show that she has made a false statement is a specific instance of conduct that does not have relevance. And even if it were to have relevance under Rule 403, showing a collateral
How can
matter.
they say it's a false statement? That's my point to them. That there is, you can argue that there are inconsistent statements, but how can they offer something for a false statement that has not been established a false statement?
Well, I'm just going on what they've said they are offering it for. They said that is their purpose for offering it.
And I corrected them.
And if but I guess their purpose will remain regardless of the court's ruling. And so what they're trying to do, and they told the court, what we want to do is show that she lied about something different than tampering with the records or anything else. Just she lied about this other thing, so you don't like her. And that's kind of what we're saying is that that particular part of it is collateral to the tampering and therefore has less probative value and therefore has more prejudicial effect.
Well, I'm going to hold on to this ruling for a little bit, and I'll hold on to the exhibit if you want, just so I can.
You vote.
I'm going to hold on to it.
Understood.
Let's get Ranger Freeman back on.
And Your Honor, are you overruling on my character?
Yes, I am.
Thank you.
So this is what I did pursuant to your other one. Is that the way you wanted it?
Yes.
It did say something somewhere.
She can't hear anything.
Hey, Regis?
Oh ready.
All right for the jury?
Thank you. You may be seated. State, you may proceed.
I'm going to hand you what's marked as State's Exhibit 21. This was previously admitted outside the presence of the jury. What do you see in that photograph?
It's a photograph of when we started during our search warrant. It's a photograph of the inside of the constable's vehicle.
And what do you see depicted in that picture?
There's a security agreement from Rodriguez Park. There's also another document. Looks like it's related to Rodriguez Park.
And then I'm going to hand you what's marked as State's Exhibit 26, previously admitted outside the presence of the jury. What is that?
This is again another photograph of while we were doing the search warrant, and it has some marks for documents that are in the visor of the constable's car.
And then what marker is depicted?
Number 7.
And I'm going to hand you what's marked as State's Exhibit 27, a photograph previously admitted into evidence outside the presence of the jury. What is that as it compares to State's Exhibit 26?
So it again is marked number 7, but it's a close-up, and it shows documents related to Rodriguez Park, to include an envelope that has dates, times, and a name and a phone number and the amount of money.
May I publish to the jury?
Yes.
So I'm placing State's Exhibit 21, on the monitor. This is what you described as marker 5. This was the back of the constable's vehicle. It was processed during the search and seizure warrant.
That's correct.
And what you described here were Rodriguez Park, a security agreement, and it looks like a calendar and notes. Okay. And then I'm going to put on the monitor State's Exhibit 26. And that's what you described as marker 7, the visor in the constable's vehicle that was processed.
Correct.
And State's Exhibit 27 is a close-up of that, and it depicts the Rodriguez Park documents.
And an envelope with name and number.
Okay.
And money, or the amount of money.
During the execution of the search and seizure warrant, I'm going to hand you what's marked as State's Exhibit 8. Was this photograph taken?
Yes.
And this has previously been admitted into evidence. And what is it in the photo?
It's what they do is entry photographs, and this is a picture of what we were the door from the lobby leading into the office.
And is there anything taped on the customer service window?
Yes, there are 2 documents that are taped on where the receptionist would talk with you.
Okay. I'm placing that State's Exhibit 8 on the monitor. Your Honor, what is the next State's Exhibit number?
$78.
I'm going to hand you what is marked the State's Exhibit 78. What is that depicting, just in general, without reading anything on it? Is that a close-up?
This is a close-up of what is posted on the window, for lack of a better term.
However, is there a redaction on this photograph? As in it's been marked out?
Yes, there's something marked out on the top of it.
Okay, and with the remainder of the document for identification purposes, what signatures do you see on that document?
They're both signed by Constable Vela.
And is there any deputy signatures on it as well?
Tony Cardona and Pena.
State moves to admit State's Exhibit 78, the redacted version of the close-up photo.
State 78 admitted.
Yes.
I'll develop. You go back. I was just going to start developing the testimony related to that. So at some point in time, did you become aware of different media broadcasts?
Yes, I did.
And I want to direct your attention specifically related to Rodriguez Park. You're going to have to help me tell me where that is in your report.
July 15th.
And what?
It's 10.1, S10, 10.1.
Thank you. I lost my place. So When you, so did you learn that there was something that might be relevant to Rodriguez Park?
I did. I learned that she had done an interview with the news media, specifically Channel 4.
And who is she?
The Constable Vela. And that interview included some comments about Rodriguez Park.
And so, because you learned this, what did you do next?
So I considered that a witness statement, and I let the prosecutor know that an interview had been done to the media about this, and I subpoenaed the news media station, and they provided a copy.
And am I that prosecutor?
Yes, ma'am.
And were you able to obtain that footage?
We were.
And have you previously listened to what we're about to play?
I have.
Do you recall who the WOAI journalist was who interviewed her? I mean, Constable Michelle, I'm using her now too.
Matthew Seedorf,
And do you recall what station that was?
News 4 WOAI.
And just for the purposes of the record, we're waiting to verify that we have the correct redacted portion related to Rodriguez Park. Move to admit State's Exhibit 74, the redacted portion as it relates to Rodriguez Park, an interview between Matthew Seedorf and the defendant, Constable Vela.
Okay.
I believe it's
Pursuant to discussion and review.
so it's previously admitted?
Yes, it's minutes.
Yes. May we publish to the jury, Your Honor?
Yes.
I'm the one who paid for the law enforcement security there on Easter Day. I'm the one who paid for the law enforcement security there on Easter Day. That's something that a lot of people don't know. We were contacted by Kenneth Montgomery, the Parks and Recs manager that's over Henry, by email as well as by phone, saying, Constable, we need 4 officers or deputies that can provide security for the day of Easter. I was like, okay, no problem, we'll accommodate. Again, I was going to have an Easter event for my office, but, you know, depending that the Bexar County commissioners, when I first took office, told me, hey, you're in charge of Rodriguez Park, you need to take care of the law enforcement security. So that kind of sometimes I have to put some things aside on my office to make sure we're able to handle the Rodriguez Park and take care of what's needed. And that's what I did. I canceled an event, went out there, we did the amount of hours that they requested us to be. Now, the problem that we had out there is that me and my chief were scheduled to work from 7:15 to approximately 3 o'clock. The individual that showed up at Pavilion number 1 was beginning to drink alcohol and so forth. Now, this individual, if you go down to the Bexar County Parks and Recs, on their forms, it'll state that they must contact the Bexar County Constable's office. So they've already been informed, and they also sign a form with them. And they're also informed that if they don't follow their policies, that the Bexar County Constables can go over there and shut down their party. Now, that's not something that we did that day. We elected to tell them you have alcohol, and this is what occurs as far as policies and procedures and the contact that you're supposed to make to said law enforcement. Nowhere in time did we ever squeeze any money out of them. Everyone that's ever rented the pavilion at Rodriguez Park has paid for law enforcement security if they had alcohol. And so that's one of the requirements. That's correct. That's exactly what it said. It said I was trying to squeeze money. Now, keep in mind, again, I've referred over to the Parks and Rec's contract, I'll call it a contract with them, where they give them all their rules and policies of what they expect and how they're supposed to contact, again, the constable's office. If they have alcohol, then yes, they are supposed to have law enforcement security. They also advise that if they don't follow this, that when we arrive at the park, that we're able to go ahead and shut down their party. Keep in mind, I did not shut their party down. I elected to tell them, this is what occurs, these are your options. And so he, at first, I believe I'm going to assume it's a wife because she referred to him as a wife, was upset saying, well, I have, my family works for a Bexar County Sheriff and they'll just come over here and take care of everything for us. Well, unfortunately, I had to apologize and say, I'm sorry, ma'am, but this is something that the Parks and Recs has with my office, that we're the ones that take care of all the security here. And as the night goes by, we actually checked out, me and my chief, at 1 o'clock from the job that we were doing for the parks. And we began providing security for him from 1 to 7, paid security, where I got $150 and Chief got $150. So it's $300 total together, but it's only $150 for each officer. Now, he also apologized to Mr. Reyes, saying, I'm sorry for being a little hard on you, but I understand, you guys are just doing your job, so we're just going to pay for the law enforcement security. You're right, we'll call your office. And that's how that went. Now, getting back to the officers not getting paid, it was me, myself, Chief, and 2 deputies that were supposed to be there at a later time. When we went to Bexar County to pick up the checks, which was approved by Bexar County commissioners for funding, the payroll didn't have our checks available. It's supposed to be a separate check from the payroll because it's a part-time job. And so that's something that, we do our own taxes and whatnot. Now, when we were over there, they weren't ready, so we opted not to go ahead and proceed forward. There was too much inconsistencies in the stories between who's getting what money and this and that I said, okay, not a problem, won't take anything today. What I decided to do was go ahead and pay both officers each over $200. And then my chief, I was going to pay him, but he decided to donate his time because he didn't feel it was right. I was paying him, and then I donate my time. My question to the commissioners was, where was all that money at? And again, the constituents they're not even aware that the Bexar County Parks nor the commissioners ever paid for that law enforcement security there. I paid for the law enforcement security for the constituents on Easter Sunday, April 21st, 2019. No one else did.
Okay.
And so subsequently, you included this as part of your case investigation in the Rodriguez Park and your case report?
I did, yes.
So at this time, I want to catch up the timeline and then mark it as an exhibit.
So, do you recall the date in your report that states when you obtained that video that the jury just saw?
Yes, ma'am. On July 15th, I got the video, but I have noted that the interview, the meeting between those two took place June 20th.
June 20th. So, interview between WAI, Matthew Seedorf, and Constable Vela took place on June 20th, 2019.
That's correct.
So we've talked about 4 grand jury subpoenas, June 11, 2019, June 25th, 2019, July 18, 2019, and August 20, 2019.
Yes, ma'am.
And the first one, as it relates to the request for Rodriguez Park documents, is June 11, 2019, and the second one with more specificity is August 20, 2019.
Yes.
And then on August 28, 2019, you received the absence of visitors records affidavit stating everything was supplied to you before on the first one,
That's right.
and no other documents exist.
Yes, ma'am.
And the return for the June 11, 2019 grand jury subpoena was June 26, 2019. Do you need to see it?
Yes.
I'm handing you is marked States Exhibit 47-1.
First one is first grand jury subpoena issued June 11th, 2019. The return date is June 26, 2019.
And then the clarification email for your request on 47-1 was what date?
July 1st was an email sent to the constable. And it's what we previously read about what I looked through and what was missing. And her reply was July the 2nd.
I'm marking it with a star because I don't have any room to put anything else up here. So it was, I'm going to do an asterisk, and then down on the bottom I'll do an asterisk, email, clarification, email between Ranger and Constable regarding clarification. Mark, what is our next exhibit number, Your Honor?
79.
There are 2 pages. Do you want them stapled or individually?
Individually.
So 79 and 80? I'll use 79 as the beginning of the sequence of events on May 9th, 2019. State's Exhibit 79. Following on to the second page, beginning October 23rd, 2019, as State's Exhibit 80. State moves to amend.
You're talking about the paper, right?
Yes, just those 2 pieces of paper with the timeline.
We're assuming you're not going to write on them anymore?
I'm done.
No objection to
79 and 80 are admitted.
Do you, in your investigations, generally give everybody you come across in an investigation an opportunity to talk to you?
I do, yes.
Did you give Constable Vela an opportunity to
Objection, Judge.
go over the evidence?
It's the same.
Judge, instruction and disregard.
Jury will disregard the question.
And Judge, we have to move for this trial.
Okay.
So as your investigation came to a close, did you determine that the cash logs that were not provided to you, the Rodriguez Park handwritten cash logs that were not provided to you, had affected the course or outcome of your investigation or official proceeding, at least up until you got them from Susan Tristan?
Yes, because I was unable to tell a full story and give all of the facts without all of the relevant paperwork related to the park.
And as we know from the grand jury subpoenas, you gave 2 opportunities for the constable's office and or herself to comply.
We did. We issued 2 subpoenas just to make sure.
And those handwritten cash logs, what is pertinent on those documents that would have helped assist you in your investigation?
Well, they named the officers, hours, times, and that will help us with interviews, who to talk to, what they did when they did it.
And at the end of your investigation, did you come to a conclusion that there were offenses violated by failing to provide those documents?
I did.
And what are the names of those offenses?
Tampering with evidence and official oppression.
Judge, may we further approach?
Can jury step out for just a minute, please? We're going to take an afternoon break.
All right, Mr. Jury.
may be seated. David, 78 is the redacted photo of the window. 9 is the unredacted that I still have.
So
78 was omitted, yes. Okay, defense?
Judge, you have to extend me some grace, please. This is ridiculous. I mean, we were clear about this. We had hearings outside the jury's presence multiple times. She's asking a question about what offense is, and then he bites for it. They knew it. They knew they were going to do this. There's no other explanation. These are not stupid people. They knew exactly what was going on. You were more than fair and more than clear of your admonishments not to talk about anything outside the motion in limine. Clear. Forget about 404B. I mean, just specific instances of conduct that are not charged. This is a charged offense, or it was. And this was no other conclusion that this was deliberate, Judge. It was calculated and deliberate. They knew exactly what they were doing. And we have to move for mistrial.
Your Honor, offenses as in count 2, there's one
Yeah,
count, there's 2 count.
but he said official oppression. So I haven't gotten off the bench during the other breaks, so I'm going to take a break and I'll come back. All right.
Of course, the state's requesting you just instructions for sure. So just regard that last statement.
Well, yeah.
So we're not on the record. We're not on the record.